One man designed Barbie by day, and her biggest rival in secret. A judge banned that rival from every store shelf in America. The company that filed the lawsuit had its own employees printing fake business cards to sneak into the rival's private showrooms. Combined legal costs for both sides passed $500 million. This is why, at some point between 2001 and 2010, you or someone you knew picked a side. Barbie or Bratz. That was never just a playground argument. Behind it was a decade of lawsuits that asked for $1.8 billion, a court order that pulled dolls off shelves nationwide, 2 full jury trials, and an espionage operation that 8 executives admitted to under oath. Since 1959, Barbie had been the undisputed queen of the fashion doll market. For over 40 years, no competitor had come close to seriously threatening her position. Mattel had sold over 1 billion Barbies worldwide. The brand accounted for roughly 20% of Mattel's total revenue, more than any other single product line. Challenging Barbie was not just difficult, it was something the industry had largely stopped trying. In 1995, a designer named Carter Bryant got a job at Mattel, the company behind Barbie. His job was designing outfits and accessories for the world's most famous doll. He left in 1998 and went home to Missouri. That summer, driving past a local high school, he saw a group of teenagers and started sketching a different kind of doll. Bigger heads, exaggerated features, street fashion instead of ball gowns. Everything Barbie was not. In 1999, Bryant went back to Mattel. This time he was designing collectible Barbies, higher-end display pieces meant for adult collectors. But he kept working on his own designs in private. He showed his sketches to a friend who freelanced at a small toy company called MGA Entertainment. MGA's CEO, Isaac Larian, initially thought the drawings looked like aliens, but Larian's 11-year-old daughter Jasmine saw them and said she loved them. On October 4, 2000, Bryant signed a consulting deal with MGA. He resigned from Mattel the same day. In May 2001, MGA released 4 dolls under the name Bratz: Yasmin, Jade, Chloe, and Sasha. Unlike Barbie and her friends, no character was the leader. Each doll was equal, each was a different ethnicity, and each had her own distinct style. In a market where Barbie had been virtually the only option since 1959, Bratz offered something genuinely different. The first year did well, but what happened over the next 4 years was something Mattel had never dealt with in Barbie's entire history. By 2005, Bratz was generating over $1 billion in annual sales. MGA had sold 125 million Bratz products. By 2006, an estimated 40% of the fashion doll market belonged to Bratz. In the same period, Barbie's own sales dropped by more than 12%. Mattel tried to compete directly. In 2002, it launched My Scene, a line of redesigned Barbies with bigger heads and trendier outfits aimed at the same tween market Bratz was dominating. In 2003, Mattel tried again with Flavas, a hip-hop-styled line with tattoos and streetwear. Flavas was discontinued within a year. My Scene never reversed the slide. For the first time since 1959, Barbie had a real competitor, and that competitor had been designed by one of Barbie's own people. In 2004, Mattel sued. The argument was straightforward. Bryant had been under contract at Mattel when he developed the Bratz concept. Under that contract, anything he created during his employment belonged to Mattel. Mattel did not just want money from MGA. Mattel wanted Bratz itself. The company filed for $1 billion in damages and full ownership of the entire Bratz brand. Mattel's CEO, Robert Eckert, said publicly that the company was pursuing the case as a matter of principle. In 2008, after a lengthy trial, a jury sided with Mattel. The jury found that Bryant had developed the Bratz concept while working for Mattel and awarded Mattel $100 million in damages. Mattel's attorneys had asked for $1.8 billion. But the damages were not the point. What mattered was what came next. In December 2008, the judge issued a sweeping injunction. MGA was ordered to immediately stop manufacturing Bratz. All 40 dolls in the Bratz line were named in the order. MGA was told to hand over all unsold inventory and destroy its molds. The company that had taken 40% of Barbie's market was being erased. A billion-dollar brand, built over 7 years, was being ordered to cease to exist. MGA appealed. In 2010, the Ninth Circuit Court of Appeals threw out the entire verdict. The judges found fundamental errors in how the first trial had been conducted. The injunction was lifted. Bratz went back on shelves. The appeals court's chief judge, Alex Kozinski, wrote that transferring a billion-dollar brand over what may have started with 2 misappropriated sketches was not equitable. He then ordered a full retrial. The second trial began in 2011. But this time, MGA came with a counterclaim. And what MGA alleged changed the entire character of the story. MGA claimed that Mattel had been running a systematic intelligence operation against it for years. According to MGA, Mattel had a department called Market Intelligence. That department operated under an 11-page internal manual. Under that manual, Mattel employees were instructed to visit private showrooms at industry toy fairs, showrooms that required credentials to enter. Mattel's employees created fake business cards identifying themselves as toy store owners. Mattel's accounting department produced fabricated invoices to back up those fake identities. Employees were given small video cameras, purchased by Mattel, to record what they found inside. What they recorded was confidential product information, unreleased Bratz designs, pricing strategies, and marketing plans for products that had not been announced yet. According to MGA, this was not a rogue operation. It was sanctioned from the top of the company. The jury heard testimony from Mattel's own people. The trial judge later wrote that Mattel's chief executive officer, its general counsel, 2 in-house lawyers, 3 former senior executives, and a current employee all admitted under oath that Mattel employees had misrepresented themselves to access competitors' private showrooms. Every one of those individuals acknowledged the conduct was sanctioned by senior members of Mattel's corporate hierarchy. And every one of them acknowledged it was improper. The same company whose CEO had called this lawsuit a matter of principle had its own executives admitting, under oath, to a coordinated intelligence-gathering operation using fabricated identities. The jury sided with MGA. Mattel's ownership claims over Bratz were rejected for the second time. On the counterclaim, the jury found Mattel had stolen 26 of the 114 trade secrets MGA listed. The judge awarded MGA $85 million in compensatory damages, then doubled it with another $85 million in punitive damages for what the court called willful and malicious conduct. On top of that, Mattel was ordered to pay MGA $137 million in legal fees. The total came to $309 million. Mattel appealed again. In January 2013, the same Ninth Circuit panel that had overturned the first verdict made a second ruling. This time, Mattel won on a procedural point. The court found that MGA's espionage counterclaim was not legally connected enough to Mattel's original lawsuit to qualify as a compulsory counterclaim. Because of that, the $172 million in trade secret damages was vacated. Not because the facts were wrong, not because the jury got it wrong, because the claim should not have reached the jury in the procedural form it was filed under. MGA tried to refile the espionage claim in state court in 2014. In 2019, a California appeals court refused to revive it, ruling the 3-year statute of limitations had expired. The espionage findings never resulted in a final, enforceable judgment. But 2 things did survive the appeals. First, the $137 million in attorney fees that the Ninth Circuit affirmed under the Copyright Act. Mattel had to pay that. Second, and more permanently, Mattel never challenged the ruling on copyright infringement. The company that had spent years claiming it owned Bratz, that had gotten Bratz banned from stores, that had ordered MGA to hand over its inventory and destroy its molds, quietly accepted the finding that it did not own Bratz and never had. By the time the litigation ended, MGA's CEO, Isaac Larian, said his company had spent as much as $170 million on legal fees. Analysts estimated Mattel's own legal costs at roughly $400 million. Combined, 2 toy companies spent over $500 million arguing over dolls. Mattel started the fight asking for $1.8 billion and full ownership of its biggest competitor. It ended up paying $137 million to the company it had accused of stealing. The designer who started it all, Carter Bryant, settled with Mattel early for $2 million. He had already received $30 million in royalties from MGA. Bratz is still on shelves today. Barbie is still on shelves today. And the doll that was once ordered, erased from existence, is still selling, in a market that still treats it as Barbie's only real rival. This is the Markup.